Thank you everyone for joining on our fifth episode, China, the Art of Law, Joint Ventures in China. Thank you for joining me, Mark. Let me introduce the series to everyone that's new and watching live. Recently, I started reading Mark's book, and he wrote this book 15 years ago, back in 2015. And we thought it would be a nice idea to kind of go back over the book and all the topics that Mark wrote about and kind of look back how things were and how they are today. So we'll be able to give everyone a fresh look on legal issues that foreign companies are facing in China. As I said, this is the fifth episode. We've already done 4 previous episodes that people can find on our YouTube channel, China, the Art of Law. Just type in China, the Art of Law on YouTube and you'll be able to find it. This episode will be all about joint ventures. What are the current trends and issues, and how could someone successfully start a joint venture? Make sure to leave questions in the chat box. I'll make sure to keep my eye on them and cover them as we go. So I was looking at the amount of joint ventures in China, and in a previous episode we also looked at the amount of wholly foreign-owned enterprises in China. And what's surprising to me is that back in 2015, we actually had a lot of joint ventures, and it seemed very popular, maybe out of necessity. How were things back then, Mark? And thank you for joining us.
Yeah, well, thanks, Jerome. So I think back in even before 2005, when companies were looking to enter the China market, I think there were 2 things about them which is different from today. Back then, most companies that we were at least dealing with were companies looking to manufacture and very often export. And so back in those old days, wholly foreign-owned enterprises were quite rare beasts, and people just thought they needed a joint venture partner. Also, there was a technical legal requirement that you had to be export orientated or very technologically advanced to have a wholly foreign-owned enterprise. But in practice, nobody really cared, because the local governments at some stage, they kind of realized, the more foreign investment was better jobs. So they were very keen. So I think back in those days, the reason for that high number of joint ventures was that people thought, well, China, it's a bit of a mysterious place. I probably need a joint venture partner. I'll have the cash and the technology. The Chinese partner will have the land, and he will have the employees and the manpower, and he'll know how to run things. And then maybe around 2005 or so, I think you saw a lot of joint ventures. Let's take a good example is the automobile industry. And so you had joint ventures like Volkswagen would do a joint venture, General Motors would do a joint venture, often with the same Chinese partner. And that was for the manufacturing of cars. And that's an example of like necessity. So you could not set up a wholly owned company to manufacture cars in China back then. So that was a legal requirement. But, particularly Volkswagen, because we did a lot with German companies, Volkswagen encouraged many of its suppliers to come to China to also to supply their joint venture in China. And a lot of those companies ended up doing joint ventures with Volkswagen's Chinese partner or with other companies. So I think that was the reason for the number of joint ventures back then.
And something that you wrote in your book is that if you start a joint venture, also keep in mind that maybe in the future you can transition this joint venture. Is that also something that you have noticed with companies like in the automobile industry? Is that something you have noticed, or?
Yeah, well, I think, probably what I wrote back then was not what I would say now. I think perhaps more clearly, in most cases, a joint venture is a bargain which is struck. And so if we're talking about nowadays, but even back then, joint ventures are never forever. I think the joint venture has a finite term. And I think, perhaps today it's more about access to market. So I think today, if you look at China, I said before, the Chinese enterprises were keen for the cash and the technology, but increasingly now, the Chinese enterprises are interested in perhaps the technology, and the foreign companies are very interested now in market access. And so I think, look, my experience has been for most joint ventures, they have a 10-year life expectancy. Some will go longer, some will be shorter, but around 10 years, the ones which are successful are either very large and have a strategic alignment, like a Shanghai Volkswagen or something like that, where it's too big to easily change things, or they've been able to grow together. Because most joint ventures are not really a separate company. Most joint ventures, even though legally it's an independent entity, most joint ventures really are the foreign partner together with the Chinese partner doing a business. And so I think it's very hard, especially in a country like China, which has developed and changed so much and it's so dynamic. It's really hard to believe that something you agreed back in 2005 is still really perfect in 2020. Maybe the factory was too big, it was too small, maybe the product's different, maybe China's got more competition. So I think what I would have meant was, back in those days, a lot of joint ventures would fail, and you probably want to transition to make it into a wholly foreign-owned enterprise. I think that's changed a bit. I think nowadays you need to work out how to get out, but really for every joint venture which I plan now, where the foreign company could buy the Chinese company out, I actually think we should also have a provision, or we should instead have a provision where the Chinese partner could buy out the foreign partner. Because I think the Chinese companies, they've also become better joint venture partners. They've become more sophisticated. They've got more global ambitions. So I think in the old days, when the book was written, most joint ventures failed because, people weren't that familiar with doing business with each other. So I think on the whole, it's improved. But now I think even more than back then, you have to really plan your exit, not just plan how you get into the joint venture.
Yeah, and we'll get into that a little bit more in depth further on. Just one last question on the trend. You did mention that the partners have become more sophisticated as well, especially compared to more than 20 years ago. Are there any regulatory changes besides maybe the foreign investment law that also kind of helped JVs become more popular again?
No, I don't think so. I mean, like the foreign investment law, if you analyze it, people look at it, probably it introduces a bit of flexibility on, how things are done within the board and how to do things. I don't think it makes a big difference. I mean, probably it does at the margins, but that would be no reason why someone's doing a joint venture. And actually, it's really the opposite. The trend has been towards liberalization. So, I think, back in, let's say in 2005, if say, 20% of the foreign investment guidance catalog required you to have a joint venture partner or required you to have a certain type of joint venture partner, that's probably been really lowered down to 5% who are on the negative list. So, I mean, obviously these numbers don't mean anything, but I think the trend has been that the Chinese authorities have opened up so much more than back then. So fewer and fewer people are, required to do joint ventures. And I guess it's something you might raise later. Even where you're required to do a joint venture by the law, like, if it's something which is involved in value-added telco, you'll see quite a lot of those companies will actually do a wholly foreign-owned enterprise, and then they will do a VIE structure, to obtain the operational license. Because joint ventures still are sometimes more difficult to obtain those kind of licenses than a purely domestically owned company.
Yeah.
So, I mean, just to summarize it, I don't think there's been a legal reason that there's more joint ventures. It's probably just the dynamics of the market have changed.
Yeah, and I'll definitely touch upon the VIE versus joint venture a little bit later on. Let's go a little bit more in depth, and we've put on the screen a few of the main negotiation issues surrounding joint ventures. And when you read the book and when you look at these topics, it's quite interesting because I already know a little bit about your view on JVs now. And the first one is, of course, structure. And I want full control, Mark.
Yeah. So I think, I used to say to people, like we had a company walk in and they were always going on about 51%. And I said to them, well, why do you want 51%? Is it because of consolidation? And this was a European company. And the guy said, no, I want 51% because I want full control. And, back when I first heard it, I said, well, if you really want full control, you should really set up a wholly foreign-owned enterprise where you own 100%. And then a few years after that, I wasn't even really sure if you get full control if you own 100%. So, I think, the idea that you will, so I think, when we talk about structure, there are some companies that have not got the mindset to be a successful joint venture partner. And, very often, like medium-sized family-owned businesses, they can either be very good joint venture partners because the person who controls the company, is interested in the China market, understands it, can make decisions, and is really involved in the business. Sometimes they can be difficult because these guys are like dictators and nobody can, say anything to them. Say, if it's a German Mittelstand company, maybe it was started by Mr. Schmidt or Herr Schmidt, and then, his son's running it, and everybody knows that Herr Schmidt makes all the decisions. And then for him, it's often difficult to have a Chinese partner who has different ideas. So I think, this is increasingly less of an issue because I think those kind of companies are doing their business in China by themselves and they're often very involved. So it's not an issue. And then I think, a lot of the companies who are doing joint ventures now are either willing to give a strong Chinese partner more control over the actual operations. So I think, there's no magic. Now with the new foreign investment law, it's a little bit different. But I would say in the joint ventures, really 51%, except for consolidation, it doesn't help you that much. Mm-hmm. Even having a majority of a board doesn't help you so much. I mean, it helps you in different ways, but the idea that you can push something through a joint venture, this mindset's very dangerous. So I think, really what happens with joint ventures when they fail, and we can talk about that in a different kind of episode later on, but, joint ventures fail because they're very static, and then you have gridlock in the board, you have gridlock in the management, leads to gridlock in the board, and it leads to gridlock amongst the shareholders. So I think the issue is with the structure, you have to kind of understand who's in charge, and if you really think that you must make all the decisions, then it's better not to do a joint venture with a Chinese partner.
Yeah, when you talk about being in control and the power structures and the board, it kind of flows into management. And what I've read in your book is that if you want 51%, you need a woofie. But if you want those soft powers, be more in control, then you need to make sure that you're the one that also gets to assign people to certain positions. Could you talk about that a little bit?
Yeah, so I mean, one more point on consolidation, I think which is interesting, which I never thought about, say, 10 years ago, but now when we have joint ventures with very strong Chinese partners, this is a big issue for them because, if they're bringing the sales revenue, because very often people will pick a Chinese partner who's got a strong sales channel in China, or they believe they do, they'll want consolidation, and then consolidation will allow them to put the financial reporting into their books. So that's something which is very important. And consolidation requires that you've got control. And so that also leads to issue with management. But very often the auditor will be happy with the 51% and perhaps the chairman. I don't think I would have written in the book, I don't have a copy of the book, strangely enough, since lockdown. So I can't remember what I wrote. But I think what I would have cautioned about is management is a big issue. And, most management structures are different. They're more like an American approach here than, say, a European or mainland European approach. So I think in many mainland European jurisdictions, you have two general managers. The Chinese find this a very disturbing concept, so they really like a hierarchical type of thing. So you will need to have one general manager. And so what we kind of do very often with European companies is we may have an ExCom, like an executive committee, And that means that individual people will report to the board. So typically what people are fighting over is the general manager position and then the CFO. But then depending on the size, it could be the CTO, it could be, the person in charge of distribution. So I think with management, it's important to have those roles. But I think what I would have even said back then is you might appoint the general manager. You may even appoint, the head of procurement. But if the Chinese partner appointed the other 500 people, do you really control it? So I think, the issue is, it's good to have those rights, but have a realistic plan. Because I think one of the problems with joint venture contracts is they are done in a very adversarial approach, and that isn't really that good. It's better to think strategically and work out how you will implement it in practice rather than have something on paper that people put in the cupboard and never look at. So I think with management, make sure you think strategically. You don't have to have all the rights, but work out the best way to protect yourself. And I think you do need to have provisions about how to deal with a deadlock and try to minimize.
That's something you mentioned, and what you just previously described is actually exactly the same as you wrote it in the book. So I guess your opinion hasn't changed regarding that. And then about the contract, you mentioned 3 points: the quorum, deadlock breakers, and appointment of the chairman. Is there anything you want to add or explain a little bit?
Yeah, so I think, with the deadlock, the problem, I think people have to be a bit realistic, and it's not, I don't think it's a China, it's only special for China. The problem is whatever you do in a contract, you need to be able to enforce it, some provision. So it's not like you show the contract to the other side and then they just surrender and say, oh, okay. I mean, they may do this, but I think with deadlocks, it's important to have something which is understandable and fit for purpose. So what people will sometimes have in a deadlock provision is 3 or 4 pages about appointing a valuation company, or everybody gets to appoint a valuation company. Then they will agree on a joint price. Then people will hand envelopes to each other. And it's an incredibly complicated way of doing things. And that'll work fine until you're in a fight with your partner, and they're not going to do it. They're not going to appoint the valuer. They're not going to jointly appoint the valuer. Or if you're upset with them, you're not going to do any of this stuff. And so I think with the deadlock, sometimes we put it in, but we do warn people that it won't go exactly like it runs, but people want to do it that way. What we perhaps do more often is we have a call option or a put option. In the old days, or previously, we more often had a call option, because normally it seemed most likely that the foreign partner would want to continue the business. Might be a complexity if that kind of business had to be a joint venture. But I think increasingly now we do have put options, and we make it that there's a bit of a roadmap to get out. And so we were looking at a joint venture contract recently, and the idea really is that if there is a certain type of breach or a certain type of deadlock, then the international partner will be able to take back its equipment, and it will also be able to terminate the license agreement. So it's quite clear what you do, but you won't get very rich out of it. Or if there's a different type of breach, you have to buy them at net asset value. So it's not pages and pages, but it's a bit thoughtful about who you're dealing with. What's your real asset? I'm really a bit tired of joint venture contracts where people have written them in an ivory tower and it's all fantastic, but you just know it's not even going to help you in a negotiation, because it's so outside of the scope of what you could do that it's actually unhelpful, because you'll be sitting in China negotiating with the Chinese partner, and someone in head office will be saying, yeah, but the contract's very clear. They have to appoint the valuer, we'll appoint our valuer, and then they have to buy it within 2 weeks. And you say, well, they don't have the money, they can't get the financing, they won't sign. Yeah. So I think, that's why I'm talking about planning the exit, work out what you want to do, because this is probably your greatest risk, I think, of a joint venture, is a deadlock at some stage.
Yeah, and I think it kind of goes right into intellectual property. And just we did a special episode on intellectual property that people can once again find on our YouTube channel, China, the Art of Law, where we go in depth about all the IP issues regarding China and foreign businesses. But just specifically to JVs, is there anything you want to add regarding IP just surrounding JVs?
Yeah, sure. So I think, look, that actually is something where the law's actually been beneficially changed in the last few years. So it used to be, there were issues about restricting a joint venture using a technology. So now you can do it much more easily. So I think, the biggest issue is the valuation of the IP. There's still some restrictions there. And then, normally one of the issues with a joint venture is who will own the improvements. So if you have the foreground or background kind of IP, and then for China, they may well add to it. So, that's an issue to look at. And then I guess also that IP, whether a lot of people have, global distribution type things, or they may have, I don't know, a distributor in Thailand. And so the Chinese joint venture can't, send the product there. And that's often connected to the IP. So I think, some of the stuff's pretty simple. So just very briefly, I don't think it's, what you should do if you're coming with a wholly foreign owned enterprise or a joint venture is a bit similar. Make sure that you've registered the IP, make sure you protect it and think strategically. So you may, even if you have a wholly foreign owned enterprise, you may keep part of the technological chain back home and supply a component rather than do a wholesale transfer. So I guess IP is always an issue, but I think the biggest problems are that people don't register, protect, or have a real strategy how to protect their IP going forward. And that's why I was saying, for example, if there's a deadlock, we've done it in a few joint ventures now, that the client can buy out of liquidation the equipment, not because they can do something with the equipment, but they just want to deny the Chinese partner from continuing the business using that kind of IP strong asset.
Then what's remaining is equity transfer. And I also note that this is something you highlight when it comes to an exit strategy, but please let us know your thoughts.
Yeah, I don't know. It's something you put in the contract. It's not particularly interesting, to tell you the truth. I think, the equity transfer is just to work out the exit thing. But most of the other stuff, I mean, I'd say a flag is if you're dealing with a state-owned enterprise, you have to realize that whatever you agree in the contract, it needs to follow the laws. And so, state-owned enterprises can't agree any price. They can't sell for any price. So it's different from a privately owned company. A lot of people have a lot of issues about, equity dilution, but the law actually kind of stops that anyway. So I think it's something to look at, but the biggest issue will be, how does it fit in with your overall exit strategy in a worst case or in a good case? And then the other one would be a bit about, is it a state-owned company or is it a privately owned company?
Regarding state-owned enterprises, Jack is asking in the chat box, in your experience, what are the chances of you fighting against the state-owned enterprise JV partners when you bring them to court? How fair is the Chinese court?
Well, I think it's a difficult question. I think it really will depend, who you're dealing with. Look, I'd rather take my chances against a state-owned enterprise in a dispute than a private-owned enterprise. So that's the first one. And so I think it will depend a lot on who the state-owned company is and where they're located. So if it's a listed company that's a state-owned company and they're listed in Shanghai, I think you've got lesser problems than dealing with a privately owned company in Guangxi province. I think, I think the most difficult person to have a fight with in a Chinese court is a big privately owned enterprise that's a main employer in a fourth tier city. That's really very tough. I think if it's a big company and it's a state-owned, they're less likely to do certain things which other people might do. But also, I don't think there's an inherent bias, especially in tier 1, tier 2 cities for state-owned companies. But again, a lot will depend on your contracts, because I think the difficulty often is that the international company, if you're in a dispute, you're very emotional and you see yourself as always the wrong party, and you very often you don't consider the other side. And if it goes to a judge, the judge may not have this natural bias that the foreign party is always right. And I think, if the contract is not well written and the evidence isn't well documented, then the judge will have a wider scope of discretion, and that's kind of the issue. So that's why I do think contracts do matter, but so does the evidentiary keeping, because it's not that the judges will make a decision saying that black is white or white is black, but it will often fall within a discretion, because joint venture disputes are not simple disputes normally. It's not like I sent you a piece of equipment, you didn't pay, you say, oh, the equipment was faulty. That's as complicated as a supply dispute normally would get, I guess. I mean, it could get a bit more. But in joint ventures, it's normally more complex. It's like a divorce or something, it would be very rare that one side is 100% wrong in a joint venture dispute and the other one's, totally blameless. So I think that's the issue. But I just to answer Jack's question, state-owned enterprises, I think, are not a bad target.
We've got 3 more points left regarding the main negotiation issues. And the first point on the screen is compliance. And when I think about compliance, I think about a story that you told me about this German company, I believe, going to China. They were in talks with this great joint venture party. And then they found out they don't own the factory, or they don't own the land. And they were working with non-compliant third parties. And so you guys, I think it was you, Mark, that told them that you found out about it, and you told the German company, hey, this is what we found, and they said there's no problem with the contract, right? And they still wanted to go ahead with it. So
well, that was actually an Israeli company, and it was much better than that. So we did the due diligence, and I went to the site. We did a due diligence at the site, and I was a bit upset that I was wearing new shoes, because I'd never been to a place like this where you could actually see something vaguely acidic, like rising out of the ground. Like, you felt like you have to have a shower as soon as you walked on their factory site. And, the best thing about it was the company that was, going to be the joint venture partner, it didn't own any of the assets of the business. And then the other great thing was the employees were not the employees of the business. And the reason for that was they had formal employment contracts with severely handicapped people. And the reason that they had, firstly, that the company's assets were, the actual business was owned by a township enterprise, and the company, which didn't have the business, employed all these handicapped people, was to get a rebate on a VAT. So the whole thing, so there was no assets, they had lots of employees, and they were handicapped employees. And I don't know much about handicapped employees, but I'm assuming they're very difficult to terminate. And so they were being investigated by the Environmental Protection Agency, and this was back about 15, 20 years ago. And normally with the due diligence, I try to always put it in context. But this thing, because the Israelis had come over, and I thought, well, this is really an autopsy. This is the most incredible report ever. And anyway, the Israeli consultant, there was quiet. There was like 5, which is very rare. With Israelis, it's normally a lot of people talking. So I finished the summary and said, this is the problem, this is the problem, this is the problem. And the Israeli consultant, after a minute of silence, he said, yeah, but if we do it as an asset deal, this will be all okay, right? So I think with this one here, this might be, if we do something on due diligence at some stage, a bit about a contract is, and look, there's lots of stories about joint ventures, so I'd have lots of them. I think the issue is the compliant model and also toxic. So, that environmental problem, it was a toxic problem. That was not an easy problem. It wasn't a problem that said, oh, this is your rep and warranty that you will solve this problem. They wouldn't be able to solve that problem. The VAT thing, this was not an asset deal problem, because somehow the assets were still going to be there, somehow the employees are still going to be there. You wouldn't be able to tell the tax office, oh yeah, we're a different group of people. So I think when I talk about compliance, you have to really work out, firstly, is it toxic? If it's toxic, you can't do a joint venture, you can't do an asset deal, walk away or run away. And then I think, with operational qualifications, we had another case where it involved arsenic baths, so you had to put like metal into an arsenic bath in order to make it more conductive or something. And we did the due diligence, and I get to Shenzhen, and this is about 10, 15 years ago. And I thought, well, we're going to go, and I didn't know Shenzhen very well. And I thought, we're going to go, into the countryside. But anyway, we turn up to a residential block, and we go to like the fourth floor, which would have been very apt, number 4. Anyway, they have an arsenic bath. Like their production is in a residential building. So it's actually arsenic gas, And anyway, the owner, he was an honest guy. He really believed, it's no problem. I'll get this license. I've got my friend. I said, can we meet your friend? So we met his friend who was in charge of operational licenses for Shenzhen. And we said, his license is expiring next year. Will it get renewed? And he said, no way on earth are we going to renew that license. So this was his friend. So I think, when you look at the joint venture, work out if it's really a big problem, don't touch it. Work out what you need to operate it. And then also third-party compliance. But sometimes, we've had clients, another case we had was the European company. They said, Mr. Wang, he wants to be 100% compliant about paying kickbacks. Anyway, I said, well, we should do some due diligence. They said, we can't do that. It's very, he'll lose face. And I said, I think he'll be okay. So anyway, we finally agreed to send an associate down for an afternoon to talk to Mr. Wang. And the associate, I just phoned him up and I said, how'd it go? He said, firstly, they use distributors because they pay kickbacks to everybody through distributors to the privately owned and medium-sized companies.
Sure.
I said, okay. I said, well, who do they not, use distributors for? He says, for large state-owned enterprises, they sell direct. I said, because there's no kickbacks.
Yeah.
He goes, no, the kickbacks are bigger, so they don't trust the distributors. So, that's the kind of things that you have to deal with. So I think that's the thing with the joint venture.
Yeah. Well, 100% compliance, I don't know if that exists, but...
Yeah, well, it's not as bad as people think, but, you can be compliant, but be realistic.
Foreign investment law, you briefly mentioned. I don't know if there's anything you want to add to that specifically, but...
No, it's a very boring topic. Yeah. I mean, I think it's improved things a bit, but it's not really very
interesting. And then we have the exit, and like you said, joint ventures tend to have a lifespan, and I think especially now that, sure, they're very popular, but as things ease up and open up, maybe it's a good way in, and then eventually down the line, you might want to change it up a bit. I don't know if there's something more you want to add to that.
I think it will really depend. Like we've got some joint ventures ongoing at the moment, and each one of these is a bit different. So I think things have become a bit more complicated. So there might be joint ventures where the foreign partner would like to buy out the Chinese partner. But also a lot of these tech joint ventures, the idea is that the foreign party is setting up a wholly foreign-owned enterprise in China and then encouraging Chinese investors to invest in it. And their exit will often be an IPO or perhaps backing it into a listed company or selling it. And that's for people that think, I can do Europe and North America by myself, but China's a bit difficult. And to make a big splash, I can't do it. It's just too big and there's too much of it. So I think, the eventual...
just for those tech companies, right?
It depends. There's very few companies, I think, that are setting up joint ventures in China, which are not, well, there are, of course, a few, but, if you think of tech, one of them is making a certain type of fabric or something, another one's doing a certain type of engineering product. And so, you know, those two are very different companies, but they do have one thing in common. The Chinese partner is a big company, and it's a big company that is in a, I don't know how you call it, but it's like on a aligned business. So they have the potential to really distribute a lot of stuff and grow the business in China. And so for those companies, you know, basically we're thinking, you know, they don't have to run the show, but, you know, if they could grab part of that growth, and in both cases, the Chinese partners are large state-owned companies, or actually in both cases, to be really explicit, they're subsidiaries of very large Chinese state-owned companies. So I think that's kind of interesting. And in those cases, they're the ones where we both have the ability to withdraw the IP and, you know, burn down the factory. But that's the exit that's kind of possible. You know, requiring the Chinese state-owned company to write you a big check and give you a, you know, guaranteed profit, which was in a joint venture contract that I reviewed, that's just, you know, senseless. You know, that won't work.
We've got a question from Matthias. From a legal point of view, is a WOFE possible if there is a joint venture between a foreign company and a Chinese one? The term WOFE indicates that shares should be 100% held by the foreign company, or am I wrong?
Yeah, I mean, one of the great things about China is things are kind of clear. So if you own land, if your name's on the land use certificate, you are. If not, it doesn't matter what long story you tell, you're not. And so in a joint venture, it's kind of clear. I mean, there might be these joint ventures without a legal identity. I've never seen one of them. I mean, like, you know, there is the joint venture with no separate legal identity. I've never seen one, but it's been around for 30 years. But I think really, you know, if it's a joint venture, it will be 100% the registered capital will be owned by the foreign shareholder. I guess it is possible that in a cooperative joint venture, which is a rare beast, I've only seen them like 2 or 3 times, you can have cooperative conditions. So that would be possible, but they're normally only used for like real estate transactions involving hotels. So I really think, you know, I can't say it's impossible. It may be possible if it's a cooperative joint venture that the foreign party owns 100% of the registered capital and the Chinese party is given cooperative conditions. But that would be a very rare beast indeed. And you'd have to look into it and see why they did it and see how they did it.
So there's a whole subsection in the book that goes about dealing with your JV partner. And I've put a few things on the screen, and there's a bigger list, but I thought I'd pull out some of the most important or things that stand out the most. The first one is don't be fooled by Guangxi, and in the first episode of this series we went over Guangxi a little bit.
Yeah.
I don't think there's too much to add about it. I mean, relationships are important, but don't be like that guy in Shenzhen that has a friend working for the department handing out the licenses. It could be his best friend, but he's still not getting any license. So
yeah, but even if he had said, look, he's going to get the license as long as I'm here, but he might not be there. So, you know, Guangxi doesn't last forever.
And then another thing is that flexibility and be understanding. I think those kind of flow into each other. Maybe you wanna highlight these a little bit.
Yeah, well, I mean, I think this one was a bit more about like joint venture contracts, and I just thought, you know, to round it off, like, you know, how do we deal with the partner? I mean, firstly, I think, you know, you have to think who you are. If you're a very inflexible person, if you really, and yeah, I'm not saying this is bad, but if you're really dogmatic and you want to do it your way or my way or the highway, it might not work out well with you with a Chinese partner or any other partner, especially someone who's in a dynamic environment that does things very differently. So I think, you know, then it might be better to be a WOFE, not a, you know, have a joint venture. Joint ventures require you to be a little bit understanding of what they're after and also be a bit flexible, I think.
We've got another question coming in from the chat, and once again, thank you everyone for asking these questions. I really appreciate it. Madeline is asking us, Mark, what do you think of the new regulation according to the new foreign investment law that 4 natural persons are allowed to set up a joint venture?
Yeah, look, yeah, I don't think it really. Again, I think this has never been an issue for me in all those years. We never had, because I think only somebody who's a very small business that would want to do that. If anything, we have the issue sometimes of not having a Chinese natural person as a shareholder, and that was sometimes a little bit annoying because there was always an exception. If the company was existing and you did an M&A deal, you could keep them in as a shareholder, but then you would have that layer and you wouldn't have the people in. So I think very, 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 very few foreign companies and nobody of a certain scale would do it that way, because why would you want to have yourself in the, then you've got really unlimited liability. You've got, every form of liability. It would make more sense to be not a natural person.
That makes sense. Going back to dealing with your PRC partner. Well, conducting a thorough stakeholder analysis, doing your due diligence, I guess that kind of speaks for itself.
I think the stakeholder analysis, I think it's just, because now, as I just mentioned, really a lot of people are looking at joint ventures in a more respectful way. So they really think, the Chinese partner, he can open the markets for me, he can do this and that. And I think 10 or 15 years ago, it was harder to find these kind of high quality Chinese companies that could really do things. But I think now it's still a problem. Many, many people say they can do this, but they don't, or they are not able to, or it's ridiculous. And so I think, have a look at what your Chinese partner really can do, not just the aspirations, but also then work out, what is your path? So if they're a very big company and, you're going to be part of their supply chain, then it's probably better to kind of work out how you could sell it to them, because that's going to be, that's where the money will be. Or if you want to do an IPO, can they do it? Or are they just good at talking? I think that's what I mean with the analysis.
Yeah, and going back to contracts, I mean, I think point 4 flows right back to contracts that, especially 15, 20 years ago, as you say in the book as well, don't leave anything up to chance. Just clarify everything up front. I mean,
well, yeah, I think there you can't clarify everything up front, and I don't really
as good as possible. Right?
Yeah, I don't really like contracts that are overly long. And look, that contract that I recently worked on, I thought it would take me 3 hours. I think it took me 30 hours because it was really a combination of a US contract with some Chinese old templates. And it was so frustrating and I couldn't understand it. There were provisions which I just didn't understand. So I don't think you have to go into detail about everything, but the things which are most likely to hit you, clarify those things. So how often did I hear in a negotiation, we can't really agree that point. Let's just leave it for now and we'll work it out later. And that could be something like, the technology, like who owns the improvement of the technology? That's a big issue. Who's got the exclusive distribution rights for certain territories? These are things, if it's really something that's fundamental to the business, decide it before you do the business. Or you should give it up because then it's not so fundamental. So I think this is the issue. And I think, look, I hope I'm not speaking out of turn, but I came across this twice where, I said, look, this is a real strategic problem. This will lead to big problems. And we had the in-house counsel from an overseas company with us. And he said, look, don't mention it because the implementation team, they're here and they say they can handle it. So it's none of our business. Our job is to get the contract signed.
Yeah.
And so that's not a healthy corporate perspective. So that's what I mean by that. I don't mean do 100-page contract or 5, because they're meaningless. I think a perfect joint venture contract would be like 35 pages at the most, of which 20 pages is template, and there's 10 or 15 pages with some thinking. That's probably what's important.
Before we go to the next slide, there's another question coming in from Rodrigo. He is asking, huh?
I haven't heard of Rodrigo for a long time.
Rodrigo
Rodrigo used to work in our office in Shanghai. I'm assuming it's that Rodrigo. I could be something else.
Rodrigo Mora is asking,
That's him. Yeah.
how do you view a foreign JV partner's ability to run compliance investigations on a JV? For example, on a matter of suspected bribery. Some foreigners might be concerned about personal security risks if they are perceived to be looking into something sensitive in the eyes of the Chinese partner.
Yeah, that's a good question. I think, again, it will be the Chinese partner. If it's a privately owned enterprise, I think it's very difficult. So we've had joint ventures that have kind of failed on compliance checks. So, that there wasn't significant access given. I think it's rare for people to have violence, because of those kind of issues. But it did happen, in the past. In one case we had with a joint venture, the Chinese partner and it wasn't like a factory, it was like a business that was like a kind of a service business. And the joint venture partner, the foreigners, wanted to replace the Chinese joint venture partner, who was a woman who ran the business, as general manager. And so she just took over the company, changed the locks, and just took over the business. And anyway, I promise I'm coming to a point, but it was an Italian partner was in this joint venture. And I said, oh, well, it's difficult. And he goes, yeah, well, we had a board meeting, and there was this Singaporean guy that we had, appointed to the board, and he got attacked by the Chinese partner. And I said, oh, okay, well, that's pretty serious. That's pretty rare. And he goes, it was nothing, very serious. Anyway, I forgot about this. And then I actually met the Singaporean guy about 3 months later, and he mentioned a bit about personal security. And I said, but it's very rare. He said, yeah, well, they attacked me. And I had remembered that the Italian guy had said, it's not a big issue. I said, yeah, I heard, but it wasn't really a big issue. And he just looked at me and just said, well, not if you don't think having all my ribs broken, my leg broken, both my arms broken, and my spleen ruptured, and I was in the hospital for 3 months. Yeah, so I don't know, the Italian guy, he must have thought, well, they didn't kill his family. But anyway, I think the issue is, I think personal safety is pretty much, safe. I think the issue would be, where I would really be worried would be in a state-owned enterprise, if I would try to dig into things, and then I might get into issues of state secrets or things like that. So I think they won't give you the access, so you probably won't find out the secrets. So that's why I think the compliance check and get those things up front, it's important, because it's difficult to go in. So I think Rodrigo's thing is, you won't get the access. And if you do get the access and you find something in a state-owned enterprise and it's a secret, then you may have a lot of different problems to deal with.
Thank you for your question, Rodrigo. We're on our final slide already, and JVs that work successful, Mark. And I think we could take a lot of lessons from our previous slides already. And I want to, what I think is that your opinion has kind of shifted around, that now the foreign companies have to think through even better than maybe before how they see things and how they envision their joint venture structure here. Please let me know.
Even better than before. I mean, I think they never really did a good job. I think, I think it's still, people don't really think about the business. They, and I mean, it's strange for a lawyer to say it, but people spend so much time on the contract, they spend much less time on the business plan. And I think, the contract, it'll have, typically, what is a joint venture? 30 years, 50 years, something like that. That contract will not be, it's not the US Constitution. Even that thing got amended. So, this idea that it's static and it's beautiful. So I think it's important, I'd say it's more important to really understand the business plan and agree that every year or two with your Chinese partner. And that's why you need to be aligned on the strategic objectives and work out those big issues like geographic focus. What's the products we're going to do? How can we make money? And this is a big issue. At least in the old days, it was very often the foreign party wanted to grow sales and didn't care about profit. And the Chinese cared about profit because they said, we have to pay for this expensive expats and all this stuff. And now it might be a little bit different. It's often the Chinese partner says, well, to kind of capture the market, we have to go to this. And so I think that's always difficult. And most joint ventures that fail, it's not because they're wildly successful. It's because they are facing, profitability issues or things like that. Yeah, and that's also connected to short-term, long-term capability transfer, technology transfer. So these are all the kind of issues I think you really do need to work out. You can't, you've got to work out the rough alignment, but then make sure that it's refreshed and then have a good way to part company as friends, because you really don't want to have a toxic breakup. It's better to have a, amicable or, semi-amicable.
Regarding contracts, Jack is asking a question. Jack asks, is it necessary to have a separate shareholders agreement, or will your joint venture agreement cover that aspect?
The joint venture contract is the shareholders agreement, so that's the same thing. And then I think the second point here is about finding the right partner. So look, I'd still say it's good to have a good contract. And somebody deleted the little joke with the asterisks, which was, so I'd say it's better to have the right partner with a bad contract than a bad partner with a good contract. But there's a funny little joke which says, but it's best to have a good contract as well. So I think that's really the issue. You can't solve major problems just by having it beautifully written in a contract. Okay.
Building relationships. I think in one of the previous episodes, one of the tips that we gave out was that you should take family holidays with your JV partner to keep the relationship fresh.
Well, I don't know if that was really a tip. It was just an example of a German client who's got a joint venture now for 25 years. And they, the general manager of that does go on holidays with the Chinese entrepreneur. I think it's a bit going far, but it seems to work. So who am I to criticize? Yeah. And then I think, I think if you've got to work out who you are. If you're dealing with a strong partner, which I think is what many of these joint ventures are now, you need to kind of realize how you can add value and make it really a joint success. Because like I said, joint ventures are not really joint ventures. They're two companies coming together. It's not a separate, well, it actually is a joint venture. It's not really an independent beast. And for that reason, I think it's also important you have the right team and governance. It's really not enough for head office to turn up for the signing and then 10 years, 15 years later say, hey, why did it all go wrong? So I think really, headquarters needs to be involved a bit, and then, build the right kind of management. And I think here, when I'm talking about the right contact points, it's really not that typical joint venture with an entrepreneurial company. It's really much more with those large companies, who you're dealing with, which company, what level of the company. Because really, if you're really looking for that Chinese partner to help you with distribution, you better make sure you're with the right part of the organization. So that's the points.
We've got one more question, our final question. Mark, you mentioned an exclusive arrangement earlier. Would such arrangement cause antitrust issues easily in China? And when do you think is a good time to assess the risks in this regard when negotiating with a Chinese partner?
I'm not an antitrust expert. So far, it has never caused a problem. I think, when I'm talking about exclusivity, it's more about if you do a joint venture in, let's say you've got a product, you're doing a joint venture in China, and you might say that you will not invest in another venture. So that's the exclusivity of the shelf. So I don't think that's an antitrust issue. It could be if there's an M&A deal and you buy. But I think China's such a big economy, it would only be for very rare cases where you would be building a certain level of business that would have a very strong market position. But I'm not an antitrust lawyer. I would say on exclusivity, though, be very careful about it because, typically what we see with the joint ventures is the foreign party is bringing in its tech or its special product. And very often the Chinese partner is not in that product. So if I ask you for exclusivity, the most common response is, "Oh, that's a good idea. Let's do it for both of us." And it's difficult. It may not make sense because your partner, you might be making cups, and the joint venture is going to make cups, but the partner does plates. It's not the same, but it's difficult. So I think with exclusivity, be careful about raising it as an issue, and then just maybe it's better to work out how to protect your specific IP rather than the blunt instrument of an exclusivity that can bite you and also can make your life difficult, where the Chinese partner is much more likely to be able to enforce it than you will be.
Thank you for that question. And this has brought us to the end of today's episode. The next episode, which will be on Friday the 30th, will be about who is your worst enemy in a China project. So we've gone from all the great projects to the worst projects, and we'll have a special guest that's yet to be announced. And I think this is an episode Mark has been looking forward to.
Yeah, so I think about who's the worst enemy. So just so people understand, so I think I will be discussing whether consultants are the worst, or lawyers are the worst, or accountants are the worst. Are your employees the worst? Is your joint venture partner the worst? Is your own general manager the worst? So it will be a very negative episode, and we're hoping to have lots of stories and.
In the meanwhile, if you're not looking for any negativity but just positivity, feel free to go to our YouTube channel, China the Art of Law. Just type in China the Art of Law on YouTube and subscribe to it. Mark is checking it daily. If you have any questions for Mark or the team, feel free to reach out, and I will make sure to send a follow-up email to everyone attending live today. I think that's it for today, Mark.
Okay, well, great. Thanks, Jerome, and thanks for all your help.
Thank you, and thank you to everyone attending live. Hope to see you soon.
Okay, great, thank you.
Thank you. Bye, everyone.